Thank you, Mr. President. Thank you, colleagues. I thought after a few in memoriams, we could probably get back to some lively debate. So I've done us all the favor of bringing forward SR 7 today. I would actually argue with the title of it. It's not really about marriage equality. What the resolution very simply and clearly does is states that the State Senate of California is in opposition to Proposition 8 because it is an improper revision of our Constitution and not a mere amendment. Article 18 of our Constitution is very clear, and our drafters of our state constitution were very forethoughtful that when radically changing our state constitution, otherwise known as a revision, Article 18 requires a more thoughtful and deliberative process, and that includes the legislature, so that there will be debate, consideration, and then a requirement of a two-thirds vote of each house prior to its going to the ballot. So you can imagine when we're talking about a radical revision of our Constitution, such as undermining a basic building block of our Constitution, a foundational stone, the Equal Protection Act, that there would have to be a more deliberative process prior to allowing voters to decide for themselves. And so that is the part that was passed over by the proponents of Prop 8, and for that reason, it is an improper revision and not a proper revision or hardly an amendment. Now, as I said in my first words, this issue before us, which will also be before the Supreme Court in oral arguments this Thursday, is much bigger than the issue of marriage equality. It really asks the question, do we have a constitutional democracy in California, or do we have mob rule, meaning that a majority of Californians can radically change our Constitution at any time? So I would just ask, even though we have clearly taken sides on the issue of marriage equality, that is not what is before us today. And again, how very forethoughtful of our drafters of our Constitution, recognizing that any minority's basic rights would be at the whim of a simple majority vote at any time. Imagine how different today's California would look if that were not the case. And I will make one historical reference. Back in 1964, actually 63, here in this legislature, there was a very controversial bill put forward by the first African-American legislator from Northern California by the name of Rumford, Assemblyman Rumford, put forward the first of its kind in the nation, a Fair Housing Act bill. This is prior to our own Fair Employment and Housing Act, which is now much more inclusive than it was in '63, and prior to the Civil Rights Act that came out of Congress in 1964. And what the Rumford Act did was prohibited discrimination by landlords or property owners in the renting and selling of property based on race. Radical concept. Clearly today wouldn't cause a ripple because we have advanced and we have evolved, and the promise of our great democracy is that much more today than it was in '63. But this caused an uproar around the state of California. Ronald Reagan, who was just beginning his bid for his first term as governor, he'd been on the ballot in '66, came out in support, along with the California Republican Assembly, the John Birch Society, and the California Realtors Association, Prop 14, which would overturn the Rumford Act and put into law a right for property owners to discriminate specifically on the basis of race. That was Proposition 14. They only need about 450,000 signatures to get it on the ballot. They collected over 1 million. Very popular issue at the time. And it passed overwhelmingly with 65% of the vote in 1964. As I mentioned, Ronald Reagan, campaigning for governor, said he supported Prop 14 and he would work to overturn, and as governor would sign legislation overturning the Rumford Act. By the time he became governor in '66, he completely changed his position and stated clearly that he would oppose any legislation. This is while Prop 14 was being adjudicated in court, that he would oppose any legislative effort to overturn the Rumford Act, and he would oppose any ballot measure that would attempt to do the same. So these issues of discrimination clearly have their fashionable time. They come and they go. Not proud moments for a revered man like Ronald Reagan to have supported Prop 14, and for having said very specifically, he believed landlords, property owners should have the right to discriminate against Negroes if they choose to do so. Those were Ronald Reagan's words and belief at the time, but they changed very quickly. So not a proud moment, but maybe an educational moment for all of us. So when we see a simple majority, even if it's not just simple, but a huge majority, such as 65%, that we recognize that we have a more deliberate process when dealing with fundamental rights, including the Equal Protection Act. And what does our Equal Protection Act say? Very straightforward. It says that no citizen or class of citizens shall be provided any privilege or immunity not granted to all citizens on the same terms. That is what makes us a constitutional democracy. That's what makes us different from so many other places around the world, because we have that right written into our Constitution. It was not amended into our Constitution. It was put there from day one. Now, we can also argue that there's a separation of powers issue here as well, because we know our high court exists for a reason, to protect the rights of minorities and to be able to be the final word in the adjudication of when the Constitution is not being respected with regard to civil rights. Prop 8 takes that responsibility away from the Supreme Court. It also takes away our legislative responsibility to concern ourselves with attempts to revise or radically change our Constitution. Prop 8 also takes that away from us because, as the resolution would state, the legislature needs to be included in the process of a revision, which Proposition 8 is. So, as I close, I just want to point out that the dean of the UC Irvine School of Law, a fellow named Erwin Chemerinsky, has said, quote, "The whole point of a constitution is to limit what the majority can do." I would ask for your aye vote.
Senator Leno, you may close.
Thank you, Mr. President. Just a few closing remarks, and thank you, colleagues. We have healthy debates on this floor and respectful at that, so I thank you for it. A couple points were brought forward. Question was, one colleague asked, are we interfering with the court's deliberation? I want to point out the resolution doesn't make mention of the court. We don't direct, we don't ask, we don't urge, we do nothing of the sort. We just state that Proposition 8 is an improper revision and that Article 18 was not respected. That's all the resolution's resolve clause states. So this is not directed to the court whatsoever. But clearly, given that we would be impacted by this lack of respect for separation of powers, that our voice would be silenced with regard to constitutional revisions, it makes complete sense that this body would make a statement in opposition to Proposition 8 because it is an improper revision. With regard to the will of the people, I want to ask you all a not-so-rhetorical question. Who among us would have supported Prop 14 in 1964? 65% of Californians supported it. Gave landlords the right to discriminate on the basis of race. Any one of us want to raise our hands and say, in fact, I think I remember supporting Prop 14. So we recognize that issues evolve. There was mention of Prop 22 just 8 years ago, March of 2000, actually now 9 years ago. Same 14 words as Prop 8 of last November. Prop 22 passed by 22 percentage points. A mere 8 years later, Prop 8 passed by just 4 points. An historically unprecedented shift in public opinion on a very debated issue. Not unlike Ronald Reagan's complete reversal on Prop 14 in just a couple of years. And I mention this because imagine what our democracy would look like here in California if Prop 8 is upheld. We'll have another vote of the people, and maybe the outcome is 52-48 the other way. and so then rights are restored. But maybe then there's another revolt 2 or 4 years later, and it flips again. That is not how our constitutional democracy works, and for good and obvious reason. I would ask for your aye vote.